quickly here before you get started. Judge Hickson has what we don't think is a conflict, but a brief disclosure. So go right ahead, Judge.
Yes, I did. I was looking at the record of this case in the morning, this morning, particularly one of the exhibits to the sentencing hearing. There was a transcript of a bond revocation hearing that took place actually in my court when I was on the trial bench in Division II. I had no recollection of it, and honestly, as I sit here, I still have no recollection of it, even after having read the transcript. It was on a case that was separate from this, but Mr. Johnson was the defendant. I did not perceive that I have any sort of ethical dilemma there. I can say the result of that bond hearing was that I did not grant the state's request to hold him without bond prior to trial. I placed some conditions on him, I believe, which included GPS. I don't feel it to be a conflict, but it is certainly something that I wanted both parties to be aware of, and if you guys had any issues with that, of course, we would be willing to hear you out on that.
Your Honor, I appreciate that disclosure. Obviously, I've reviewed the record, but wasn't focused on that issue because it's not one that I've raised on appeal. So in light of that, I'm prepared to move forward.
Okay. Thank you, sir.
General, do you have any
I
objection?
perceive no issue, Your Honor. Again, it's an issue separate from any of the issues raised in this case, and so I certainly see no conflict at this point.
Okay. Thank you all.
Thank you.
Thank you.
In light of that, thank you. I am Robert W. White, Sr., and I represent the appellant, Tyler Johnson. And I would like to reserve 5 minutes for rebuttal, if I may.
Certainly.
And may it please the court, I have raised 4 issues in the briefing. 2 are related to the sufficiency of the evidence for it was a 5-count presentment. Counts 1 through 4 charged Mr. Johnson with rape, 2 counts by lack of consent, and 2 counts by physical helplessness. He was convicted by the jury of all 4 of those counts, and by way of merger, it resulted in 2 convictions. I would like to address first, if I may, the sufficiency of the evidence related to the rape case, and of course, or cases. The issue as to and I believe these can be addressed in conjunction as to the lack of consent or physical helplessness. I would submit to the court that the record contains the only account of the sexual acts that occurred, and that is not a fact in dispute that fellatio occurred and intercourse occurred. But the only account of those is the statements of the defendant himself. The underlying facts, of course, are that Mr. Johnson picked up MP as she was walking beside or in the street, and that in the Fort Sanders area of downtown Knoxville, and they proceeded for a period of time in the car that he was driving. The account that he gives is that at some point in time, while they were traveling in the car, that she initiated the sexual encounter. Her account is simply that she does not remember what happened. And of course, on an insufficiency of the evidence standard here on review is evidence taken in a light most favorable to the state after conviction. Could the jury still return a verdict of guilt? And I would submit that the proof in the record on this case, that simply a statement that I don't remember by MP would not be sufficient. And there are several items of testimony that I submit that are important to that analysis. The state called several witnesses. One was a Miss Whittick who encountered MP in the dorm room at the University of Tennessee right before she went to a house party, which subsequently ended up in the car with Mr. Johnson. Ms. Whittick's testimony was that she saw her leave the party and that she appeared fine. MP's account is that she recalls having 2 shots of vodka, nothing more. There was also testimony that MP was seen leaving the house party, a friend there by the name of Molly, and that she appeared fine. She thought she would be okay. There was no cause for concern. There's testimony of another friend of MP's, Ava Fitzgerald, who testified that she FaceTimed MP while in the car, and that she actually spoke to Mr. Johnson on FaceTime as well, and that MP was able to relate that she was in a small sedan, she was laughing, she was not acting scared. The other, I would submit, very important piece of evidence, which I believe is Exhibit 22 in the record from trial, was the body camera footage of Officer Adams. And I submit it's really important. This is after that individuals, Mr. Johnson and MP, are back in the UT campus area, the Cumberland Avenue area, and a traffic stop's ensued. The traffic stop was related to Mr. Johnson going over a curb and some other erratic driving. But that body camera footage is very telling, because when MP is asked, can you get out? Can you get out for me? And she's in the passenger side of the vehicle. She says yes. She's then asked, is your name? And he asks her first name. She replies correctly to that response. And she's asked if she's missing. She says, no, I'm not missing. She's asked how old she is. She gives the appropriate response for her age. You can also observe on this video that she's walking without assistance. There's also the testimony from Knoxville police officer Nicholas Adams, who they asked the defendant, do you need medical attention? And she refuses medical attention. So they rely on her ability to communicate to make that own decision, and they release her to her brother. She can be observed walking back to the patrol car without assistance, and she's directly asked, were you touched inappropriately by the person you were in the car with? And she replies that she was not. So I would submit that there's not, even under a lot most favorable to the state, evidence contained in the record sufficient for the rape convictions, because her behavior does not indicate that of lack of consent or helplessness. And the only evidence to the contrary I would submit is her testimony that she does not remember.
I'm sorry, maybe I'm missing, I've read a lot of records in the last few days, but wasn't there a blood alcohol twice the legal limit?
There is a blood alcohol level. If I recall correctly, I believe it was .17 or somewhere in that range.
Okay.
But that was taken many hours after.
It was, which raises the question, if the proof in the record is that she recalls having 2 shots of vodka. There's no recollection or proof of her drinking anything else. No one remembers her drinking anything at this house party or testifies to that. There's no testimony or proof that once she got in the car with Mr. Johnson, that there was any alcohol consumed. And there was no alcohol found in the car. So,
But the friend
yes.
that testified and FaceTimed her, I believe, if I remember this record correctly, instructed the defendant driver to bring the victim back home or to a location, given the observance of the victim's condition. Is that not accurate?
There is testimony in the record to that, but there's also testimony that I don't believe is refuted, that MP herself made no request to be returned.
Doesn't that
at
vote against
time.
your argument?
Well, I submit that it doesn't, because there's no indication that, because it's around that same time that she appears laughing and not scared or anything to that effect. So I would submit it doesn't go against that argument. But back to the point of the blood alcohol test, it was several hours later, which is inconsistent with the other proof of the lack of alcohol consumption, and we don't know anywhere in the record what happened after she left the scene once she returned in those hours later when she was with her brother. So that would be my response to the blood alcohol consumption, and not knowing exactly when that happened. So as to the insufficiency of the evidence, I would submit that a verdict here of rape will require conjecture, or the mere possibility that the encounter was not consensual, and that there's not sufficient proof in that regard. As to the kidnapping, I would submit that there's not evidence to suggest substantial interference with her liberty. The proof is that she got into the car voluntarily, and at that point, there's a friend there in plain view that said, I was watching her leave and I thought she would be fine. So there's not indication that she was under the influence to an extent that she was physically helpless at that point. And the description of the sexual encounter appears to be one of, I would suggest the record reflects spontaneous. The only description of it is from the defendant, who says she initiated while they were driving. So, and then once that happens, then they return to the close proximity of where they left from, the Fort Sanders, Cumberland area of the UT campus. So I would submit that there isn't a kidnapping, there's not substantial interference, and there's not removal to commit a felony, in this instance, the rape, for that instance. The other issue that I have raised is the comment by the district attorney in closing argument, "Can I search your phone?" To which the defendant asserted no. Obviously, that's a Fourth Amendment issue that we deal with those pre-trial for a very reason. I know that that was not objected to at trial, and in my initial brief, I did not ask for a plain error review. However, I know the court can address that. I do believe it's a clear an unequivocal rule of law that's been broken, one of the most sacred ones, the Fourth Amendment, with improper argument commenting on his Fourth Amendment right to refuse a search. The other issue that I raised was that of consecutive sentencing. And as noted by the trial judge in this case, under 4035-115, the only applicable factor for consecutive sentencing in this case would be the defendant is a dangerous offender whose behavior indicates little or no regard for human life, and no hesitation about committing a crime in which the risk to human life is high. That's obviously reviewed under an abuse of discretion standard. However, I would submit that there's not proof in this record, although the convictions are, needless to say, very serious and are often associated with scenarios where the risk to human life is high, but not in this instance. In this instance, the allegations are simply that a rape and kidnapping occurred while someone was physically helpless or not capable of consent, but there is no proof in the record of physical injury. There is no proof in the record or allegation even of an act of violence. And in fact, as to the kidnapping, I would submit the risk of human life would have been higher had she not been returned to the area where she was taken from. So I would submit that the proof in this case does not support consecutive sentencing, because there is not proof in the record that the risk to human life was high. And I see that I have used my time. If there are no questions, I'll yield to my adversary.
Thank you.
Thank you.
Your Honors, may it please the Court, Johnny Saraceno on behalf of the state. In December of 2021, the Knox County Grand Jury indicted defendant on 5 counts. The first 4 are rape conviction or rape counts. They were after trial, after the convictions, they were merged count 2 into count 1, count 4 into count 3. And then the court sentenced defendant as a standard offender for to 12 years for count 1, 12 years for count 3, and 12 years for count 5. These were run consecutively. Regarding the underlying facts here, I think it just would really help contextualize things a bit more. On January 30th of 2021, around 9 p.m., the victim in this case, Michaela, consumed alcohol in a dormitory with her friends as part of a pre-gaming ritual before going to a house party. When they went to the house party, and shortly thereafter, Michaela decided to leave. She decided to walk out the door, and that's exactly what she did. Around 10:30 p.m., her friend, Ava Fitzgerald, became concerned about her well-being and safety, noticed that she hadn't arrived at the dormitory, and so she made a video call to Michaela. When Michaela answered, she saw Michaela in a stranger's vehicle. She said regarding her appearance that Michaela appeared to be intoxicated and that she couldn't maintain a coherent line of thought. She couldn't, quote, keep a thought. And she appeared with this stranger, this individual who was later identified as being the defendant. She spoke to the defendant and said, will you drop Michaela off at this location? The defendant agreed, but the defendant never arrived at that location. Instead, for a period of 2 hours, Michaela was radio silent. During this period, her friends, family tried contacting her, calling her via FaceTime, making phone calls, leaving voicemails, text messages, about 150 in total during this period of time. And as this was taking place, during these 2 hours, her family, friends, and law enforcement tried to find Michaela. They tried to locate her via a phone application that gave her general location. Eventually, police found Michaela. They pulled over the defendant in the Fort Sanders area, conducted a traffic stop, and found both defendant and Michaela inside the vehicle. When she exited the vehicle, there's video footage, body cam footage of what Michaela looked like. And I would encourage a review of that footage because it's clear that she appeared very intoxicated. And many witnesses at trial, friends and law enforcement officers, testified to the extent of Michaela's intoxication. One said it seemed like she had a mental fog, didn't know where she was or what was going on at that point. The video shows that Michaela was slurring her speech, repeating the same statements over and over again, and that she couldn't provide coherent answers to simple questions other than perhaps her name and age. She was also unstable on her feet. My friend on the opposing side here has noted that she was walking on her own, but many witnesses said she was very unstable and nearly fell to the ground multiple times. Family friends said when they walked her back to her apartment, she was stumbling and they had to hold her up to keep her upright and keep her from falling down. Regarding her clothing, she was disheveled and partially disrobed and didn't seem to be aware of the state of her condition, despite the fact that this January it was, quote, very cold outside and it was sleeting. To emphasize, her pants were unbuttoned and unzipped, her shirt was pulled over her chest, and she seemed to be just oblivious to that fact, despite the public nature of the traffic stop. In the early morning, Michaela's family took her to the hospital. There she consented to testing with a rape kit, which a vaginal swab revealed the presence of male DNA that matched defendant's genetic profile, and a buccal swab from Michaela's mouth indicated the presence of male DNA as well. Again, just to emphasize that blood alcohol level, it was a 0.173, over twice the legal limit, and that blood alcohol sample was taken 9 hours after she disappeared, I believe.
Did the state's expert offer any extrapolation on that as to what it could have been at the time of the offense?
I don't recall seeing that in the trial record, Your Honor. No, I don't believe that there was specific testimony regarding what a 0.73 might have been prior to that point. No. I believe the state relied almost exclusively or primarily on the video evidence and the testimony from law enforcement officers and family friends regarding the severity of Michaela's intoxication. Regarding the sufficiency of the evidence for the rape convictions, on sexual penetration, my friend has noted that there's been no contest regarding or no contesting the acts of penetration. Defendant admitted in on video during a discussion with law enforcement that he penetrated Michaela vaginally and orally. But the evidence is certainly sufficient to show that Michaela was too intoxicated to consent to any sexual act and that she was physically helpless. Again, I don't want to reiterate too much, but the evidence that I mentioned earlier, the testimony that she was very intoxicated, that she was slurring her words, that she couldn't give coherent responses, that she couldn't stand upright, she was unsteady on her feet and falling down, that she was barely clothed despite the cold and the sleet, there was a great deal of evidence, again, from officers, from friends, from family, and from family friends regarding the severity of her intoxication. And then, again, I'll just highlight that 0.173 BAC. The record also shows that defendant knew Michaela was too intoxicated to consent to sex and that she was physically helpless. Defendant had 2 interviews with law enforcement, 2 separate interviews. During one of them, he said that Michaela was very intoxicated. Defendant described Michaela's appearance, quote, she was walking down there, through there, drunk as could be, period, close quote. He also indicated that Michaela was weaving. His initial thought was, quote, damn, she gonna get hit, period, close quote. Defendant also stated that Michaela tried to exit the vehicle at one point, and this is important to both the rape and kidnapping conviction. But he refused to let her out of the vehicle. He said, "No, you can't get out here because you're drunk and you can't walk in the rain. Someone's going to hit you or something," period, close quote.
Does it matter at what point that occurred?
Does it matter at what point that occurred? I don't know that it does, Your Honor. This was a 2-hour ordeal where defendant and Michaela were in the same vehicle together, where Michaela was entrapped or was trapped in this vehicle. I don't think it does matter.
Because there's no dispute that you got into the vehicle voluntarily.
I would say that is disputed, Your Honor.
Based on the lack of, the state's position is that the fact that she was intoxicated, basically when she got into the vehicle, that's when the kidnapping began?
Certainly. I believe it is, Your Honor. And if it's not that point, there is testimony from the record from defendant that she was asking to go to Maddie's house, that she was asking to go elsewhere. And that is also corroborated
Do we
by...
have to identify when the kidnapping began and when the rape began?
So we don't know exactly when the rapes occurred. Defendant claimed that the sexual penetration happened on where the road turned from a 4-lane road into a 2-lane road. He said that there were no distinguishing markers in the area. There was also trial testimony that defendant stopped multiple times. There was some suggestion that the defendant stopped multiple times in different areas during this 2-hour period. But defendant claimed that this all took place on the side of a road with no distinguishing markers. He couldn't really identify beyond this change from a 4-lane to a 2-lane highway. Regarding the kidnapping, the point at which that occurred, I think it would be reasonable to conclude that it happened as soon as she got in the vehicle. But it certainly occurred at the point that she was asking to go somewhere and defendant did not take her or drop her off. And again, that's corroborated by the fact that Ms. Fitzgerald spoke with defendant and said, you need to drop Michaela off here, and defendant agreed to and then did not. Also, I'll highlight the fact that defendant was not unaware that what is further corroborating the kidnapping is that throughout this entire exchange, people were constantly calling and attempting to contact Michaela. Defendant admitted that her phone was ringing off the hook the entire time. Michaela's sister testified that she alerted the phone. She put it in some sort of emergency mode or Find My iPhone, where it would blare a siren noise or a very loud and intrusive alarm indicating where the phone was. And so this was happening the entire the span of the 2 hours. Starting at 10:38, once Ms. Fitzgerald realized that the defendant was not going to show up at the location that was agreed to. So again, just turning back to the sufficiency of the evidence, I'll move on to the kidnapping. My friend on the opposing side here has also mentioned, beyond the evidence I've discussed, that the kidnapping was sort of incidental to the rapes, or that this was all sort of incidental to the other offenses, and that is just simply not the case. Again, Michaela was gone for 2 hours. There was certainly the kidnapping was certainly much longer than what was necessary to effectuate the other crimes. Regarding...
General, I'm sorry, I'm assuming a what instruction was given?
I would defer to the record on that, Your Honor. I'd have to double check. I'm not certain off the top of my head. I believe so. I believe so, though. Actually, as I reflect on it, I think there was.
No one said in their briefs that it wasn't given, but
yes, Your Honor.
Assume.
That's correct.
How do we know? Never mind, strike that. I'll just have to review the record closer to the kidnapping and the rape. The state's position is that the kidnapping occurred upon entry into the vehicle.
Yes, Your Honor, or alternatively, at the point that Michaela said, "I'm trying to go to Maddie's house. I'm trying to go to another location."
At the point that the victim or the friend said?
The victim.
Okay.
The victim. I want to be very clear on that Michaela was asking to go to a location. That is corroborated and clarified by the testimony of friends, or the friend Ava Fitzgerald, that she was trying to coordinate with defendant to ensure that this in fact occurred. Regarding the third claim here, that the state violated defendant's right to silence or improperly commented on defendant's Fourth Amendment right, I think this claim is waived if it's about the right to silence. It's been a little unclear to me from it was unclear during the initial process of briefing and what I wrote in my principal brief. And a footnote was, it's not entirely clear whether defendant is concerned about his right to remain silent, but it appears that this is his concern given his citations to State versus Jackson, which addressed a prosecutor's comments on defendant's silent during closing argument. It wasn't clear to me when I briefed the issue whether this was an improper comment on silence or the Fourth Amendment. That wasn't really clarified until the reply brief, and so I would argue for that reason the issue is waived. I would also point out that although my friend on the other side here did address or raise the issue of plain error review in reply, there was no interaction with the plain error factors, not from what I saw. And so I'd also argue that this issue is waived for that reason as well. However, just turning to the merits briefly, the state's comment on defendant's refusal to comply with a lawful police investigation was not improper, and so defendant is not entitled to plain error relief. Regarding a breach of a clear and unequivocal rule of law, there just hasn't been that in this case. To give some context, this was really a response to something that defense counsel, trial counsel raised. And so the context of the state's comment shows that it did not challenge defendant's silence or his Fourth Amendment rights. It was simply a rejoinder. Defense counsel said, quote, "Investigator Wardlaw could have got the cell phone tower records. Yeah, I can absolutely do it. Track it to almost a reasonable certainty. Didn't do it." It was then on rebuttal that the prosecutor responded, quote, "Location, wanting you to talk about, well, for Michaela's phone, you dumped the entire phone. You didn't get the cell tower location. I want to go back to defendant's phone." The state then emphasized, quote, "Defendant is asked, can I search your phone? No. And when they try to subpoena the records, well, the phone number you gave Investigator Wardlaw, that's a new number, isn't it? Deceit, trickery, period," close quote. It's apparent that the prosecutor's comment didn't have to do with defendant's right to refrain from testifying, nor his Fourth Amendment rights. What the prosecutor was doing, the thrust of this statement was pointing out defendant's refusal to comply with a lawful request for evidence, a subpoena for defendant's phone number, and he offered a new phone number, one that he did not use at the time of the incident. So this was really about a response to accusations of a sloppy investigation and responding to the accusation that, the state just didn't do enough. And so it was, defense counsel invited this comment by nature of his argument. Finally, on the fourth issue, consecutive sentencing, there's no problem here. First, this is reviewed for abuse of discretion with a presumption of reasonableness because the court considered the purposes and principles of sentencing and gave in-range sentences for each of the convictions. Then, regarding its sentencing decision, it addressed both the relevant statutory provision as well as the Wilkerson factors and discussed them at some length. Citing TCA 4035 115B4, the court stated that defendant was a dangerous offender whose behavior indicates little or no regard for human life and that no hesitation about committing a crime in which the risk to human life is high. And making this finding, the court observed the state's arguments. And to just give a little bit of context here as well, there was substantial testimony not only about the impact on the victim, but also regarding defendants, and this will become more relevant regarding the Wilkerson factors, but regarding defendants' pattern of conduct, particularly the fact that he had, there was substantial testimony from people who said that they'd been approached, solicited for prostitution by defendant, that he had messaged a 15-year-old girl asking for explicit photographs, and that he knew that that this girl was in fact 15 years old, that he was banned from not just UT's campus prior to the incident, but also another campus for stalking, soliciting, engaging students inappropriately, offering them money. And there was a particular account from an individual who said, talked about him, the defendant, approaching her in her home or at her home and acting in an aggressive manner. Regarding the victim impact here, regarding what resulted from these acts, the record confirms the trial court's finding. Again, the defendant kidnapped Michaela from a place of relative safety. She was near the University of Tennessee's campus, near her dormitory, at a party among friends, and then isolated in his vehicle. It took her away from Knoxville, about 40 minutes away, to Granger County, where somewhere around that area is where the rapes occurred. Defendant did this while Michaela was especially vulnerable due to her severe intoxication, and the result was significant harm, physical harm, but especially psychological harm. And a defendant exposed Michaela to several safety risks. Regarding physical harm, Michaela's mother testified that she had to take Michaela back to the doctor a week after the attack, quote, because the damage the monster did to her vagina, period, close quote. So there is indication of physical harm. Regarding psychological safety, Michaela testified to struggling with nightmares, needing multiple medications to help her sleep, and extreme fear of the dark, physiological responses to this psychological trauma. And not to mention suicidal ideation following the incident based on the incident. So the record is clear that it placed her in a place of terror, that that defendant caused physical harm. He also admitted that he did not use protection during the rapes, and so he exposed her to risks of sexually transmitted disease and pregnancy. And he compounded this risk by raping her orally and vaginally. On the Wilkerson factors, the circumstances
General,
of the...
Before we move on to the Wilkerson factors, I would like to just focus on the text of the statute there in B4. And before I ask this question, these are obviously serious, heinous offenses. The other conduct that was demonstrated during the sentencing hearing is also disturbing, I think, to say the least. But looking at the text of this statute, an offense that indicates little or no regard for human life, and he had no hesitation about committing a crime in which the risk to human life is high. When you look at that text, that's a pretty stringent requirement to meet that element. And I know Mr. White has cited some cases in his briefing where obviously that's been applied in some very extreme situations where obviously the victim's life was in danger. Can the state get there here in this case? High risk to human life.
I think so, Your Honor. And again, what I would point out is the kidnapping Michaela from a place of safety, her severe intoxication, leaving her defenseless in this particular situation, as well as the fact that she was gone for 2 hours while her family was trying to hunt her down. We don't really even know everything that happened in this particular case. We know that the vehicle stopped several or multiple times, more than once, and that she was raped at least twice. Defendant refused to let Michaela get out of the vehicle. She was trying to self-preserve. Her friends were trying to help her. And so and even when she was being returned to the Knoxville area, it's not clear that defendant was trying to put her in a place of safety. And so there's no telling where she would have been dropped off had police not intervened and found her. And again, I'd also highlight sort of the psychological suffering, the terror that she experienced. And I know you have heard what we've discussed, but I just want to emphasize that the suffering has been immense and that defendant certainly acted with no regard for human life when the risk was high, not only because of the crime itself, but because of the circumstances around the crime, the fact that she felt helpless and defenseless, and felt preyed upon after the fact. These indicate a disregard for human life, and I think reasonably show that her safety was in great jeopardy by nature of defendant's conduct. Regarding, unless there are further questions on that issue, Your Honor, I'll just briefly mention that the Wilkerson factors were satisfied, that the offense was particularly grave for the reasons I mentioned, and that there is a risk to protect, there's a need to protect society because of defendant's past history of this sort of conduct and the nature of this offense in particular being especially concerning. Unless there are further questions, we ask that you affirm the sufficiency of the convictions. Thank you.
Thank you, General. Mr. White, rebuttal.
Thank you, Your Honor. Just, Judge Hickson, to answer your question, there was a white instruction given, so just for clarity on that.
Thank you.
I'd like to focus a little bit on the statement that she was taken from a place of safety. As to the consecutive sentencing issue, it appears as though that the state is trying to have both sides of the apple. I mean, they want to argue that she was incapable of taking care of herself. And I think that's important when we're looking at the factor that was used to apply consecutive sentencing to all three of the convictions after merger, 3 convictions. Because, of course, consecutive sentencing is not favored under our code. And so the risk to human life was high. The proof in the record was that she was wandering down the street. Now, on one hand, she has a friend who says she thought she would be fine, but on the other hand, there is testimony, and of course the jury chose to convict on physical helplessness or lack of the ability to consent. So I take issue with the state's argument that she was taken from a place of safety. Now, what happened after she got into the car? Obviously, we've disputed sufficiency of the evidence, but as to the issue of sentencing, she was in the car, which is safer than the place potentially that she was wandering around, and then she's brought back to close proximity of where she was. I submit that there would have been greater risk to her safety if she had been put out of the car somewhere along this journey, or had gotten out of the car in the middle of nowhere, or things of that nature. So I know it's an abuse of discretion standard, but I submit that the proof here does not support consecutive sentencing, because we are dealing with issues of lack of consent. We're dealing with issues of physical helplessness. The examination, I can't recall the witness's name, but the nurse that examined her showed no signs of any physical issues with her body. This is not a situation which I would submit, unfortunately, we encounter in cases like this where someone is beaten severely, or a gun or a knife are employed to commit either a rape or a kidnapping. This is simply just not. There was, and not trying to minimize these offenses whatsoever, but the risk to human life, there's just no, being high, there's no proof in the record to support that. I also wanted to touch briefly, of course, on the rape, another element that has to be proved by the state is that for sufficiency of the evidence that the defendant knew she was physically helpless or incapable of consent. And that has to be proven, of course, beyond a reasonable doubt. Although the defendant was not arrested for DUI, he was pulled over for erratic behavior. When asked for his driver's license, he gave, I believe, an insurance card. I think that's correct. I know it wasn't his driver's license. And he was not allowed to drive his vehicle home. Other individuals were called to pick him up. So I would ask the court to consider that in light of the
Was this an affirmative defense raised below? Is that what you're saying?
I'm sorry.
Are you saying that this was a defense raised below, that he could not appreciate the knowing nature of the offense?
Well, I submit that the state didn't present evidence to show that, sufficient evidence to show that he knew, had the ability to know she was incapable.
Did you argue that he had a diminished capacity in this case? Did you make that argument below?
Did not. And if there are no further questions, it looks as though I'm running to the end of my time. Thank you. On behalf of Mr. Johnson, we respectfully ask the court to overturn his convictions, or in the alternative, to overturn the consecutive sentencing. Run those concurrent.
All right,
Thank you.
Thank you, Mr. White.
Thank you.
Next case, please.
James Davis Duncan,